Our competitors often charge you for small things like photocopies, even interest on the stamps they loan you. Don't be nickel and dimed by your lawyer. Hire expert lawyers for less. Pick the experts at Phillips and Hunt.
Isn't that clever? Good job, John Lawless, with my office. So today's video is about contingency fees, and then, kind of what goes into a contract where you're not retaining a lawyer in usual fashion. So let me go through it. So, if you have a business dispute or certain types of arrangements like a criminal defense, so you get arrested, you need a lawyer. That lawyer is going to tell you to pay a flat fee, typically, or hourly fee, and they're going to help you through your criminal case. At our firm, we charge a flat fee up until trial. And then if we have to go to trial, then it depends on how complicated that trial is. In family law, Matt Hunt charges a retainer. And then once that retainer is done, there's hourly commitments that a client makes depending upon how long their case lasts. Personal injury, wrongful death, and complex civil cases are different. So somebody a long time ago decided, wait, injury victims cannot afford to just chase an injury recovery by paying money up front. Time out. History lesson time. The word of the day related to contingency agreements is champerty. 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 And you got to go back. All of our laws we brought over with us from England. Like, that was the original basis. How we set up a government, was influenced by English common law. And I'm not going to get too historical or too boring here, and have you tune out just because you're dying of boredom on legal history. But champerty is the concept of a contingency fee agreement for somebody that can't afford to pay. And it was absolutely illegal in the 1600s, 1700s, 1800s in England. The law wanted to protect business. It wanted to protect the wealthy. And so nobody could loan anybody of any means, of any level of victimization, money to hire a lawyer and challenge the status quo. Again, the king is the one that's in charge. The crown is the one that's in charge. The businesses are at the permission of the sovereign. So they didn't want anybody to be a threat to that. And fortunately, during the founding of America, we said, hold on. Let's challenge champerty. Let's see if that's fair. And some of the OG lawyers of America, tried a little bit along the way to say, wait a minute, our clients were wronged by this industry or part of the Industrial Revolution or deeds, but yet you're going after the extreme wealthy, and it's completely unfair for the rich to have not only all the power and be able to hire the lawyers they want, but have laws that prohibit anybody challenging them. And the way America developed to allow largely the people who left England or were sent here that weren't the wealthiest, because of our desire to protect the little man in a time of civil war and industrial revolution. The laws changed. And so the contingent agreement, where it's no fee until we get to the point that somebody else is paying our fee, used to be illegal. And then in America, late 1800s, mid to late 1800s, it became legal. Now, what you see now with all the commercials obviously didn't exist. But all those commercials you see, the no fee unless you win, the you don't get paid until we get paid, no check, from your wreck until we win kind of thing. That used to be abolished. I know some would like to see some of those commercials abolished, but it's from a concept called Champerty, which prohibited the current contingency fee arrangements that most victims need to be able to challenge large insurance companies, large companies. I mean, even in high-end, commercial and civil litigation, where one small company is challenging a large company, why give that large company the best lawyers and the best advantage? Why not give, good lawyers a reason to represent the little guy and balance the scales? That's what America did right with the justice system, in my opinion.